We've spoken a few times about how police who are witness to their colleagues' unlawful actions and who get no punishment should in fact be punished for not stopping it, seeing as they are there to uphold the law, even if the person breaking the law is their colleague. And this takes us back over the water, the great watery divide, to the USA again, where a policewoman has been jailed after she was caught on body-worn video laughing while her colleague broke a 73-year-old woman's arm and dislocated her shoulder. Colorado police officer Austin Hopp twisted the arm of 73-year-old Karen Garner and pushed her to the floor as she picked flowers after she had left the Walmart store without paying for goods valued at $14, around £10 here. The 12-minute video footage showed how Karen Garner, who suffers from dementia, was treated by both Hopp, who inflicted the injuries, and Daria Jalali, who stood by and laughed back in 2020. Hopp was thankfully sentenced to 5 years in prison in May this year after pleading guilty to second-degree assault, and the city settled a civil case regarding Mrs. Garner's arrest for $3 million in September of 2021. However, Daria Jalali was sentenced to just 45 days in jail, followed by 3 years of probation, for a case the presiding judge described as incomprehensible. In fact, Daria Jalali is the first Colorado police constable, or police officer rather, to be sentenced under Colorado's new non-intervening law, which I will explain more of at the end of this video. But it is definitely worth a listen to. This cretin who stood by and allowed these injuries to be inflicted on an elderly woman with dementia deserves far more than a month or so in the slammer. Judicial District Court Judge Joshua Lehman said, "It is just tragic that this even happened, and it was compounded by your continuous choices that you made throughout the 2 hours you were with her. You need to recognise that." John Stewart, Mrs. Garner's son, said his mother was a wonderful family member who loved spending time with her family and baking. He added that his mum did not deserve what happened to her, and that Jalali had every opportunity to stop the cruelty and do the right thing, but did not. Alyssa Swartz, Mrs. Garner's daughter, said not sure how Jalali can be proud in her assistance in the arrest of Garner, who she says was not only 73 years old, but just 5 foot tall and less than 100 pounds. Ms. Jalali was given a badge to protect and to serve, and that is not what she did. John added that he will never forget the footage that he had seen of his mother's arrest, and that Jalali has no idea the stress, pain and sadness it has inflicted on their entire family. We all have choices to make in life, he says, and all our choices have consequences. I ask that justice be served for my mum today. And if you ask me, 45 days is not justice. But of course, it's good to see the city admitted liability and paid the family a tidy $3 million settlement, although it's not about the money. The problem is, this kind of thing happens over here, and it's the offender themselves, the police offender themselves, that gets misconducted, and not the people that are with them. Remember, the police are there without fear or favour, okay, to protect and serve the public, okay? When a police constable oversteps that boundary between policing and becoming a criminal by breaking the law and hurting somebody, then the colleague needs to be stepping in. There's no question about that, and there's no excuse for not doing that, which is why it's so shocking when we see it happening all the time. Now, heading back to Colorado and Senate Bill 20-217 concerning measures to enhance law enforcement integrity and, in connection therewith, making an appropriation. In this new bill introduced in Colorado, it actually states two things that we've been calling for here for some time, and actually makes failure to follow them a criminal offence. The first is, as I've said, failing to intervene. Provides that a peace officer's certification can be revoked under 24-31-904, where it says, notwithstanding any provision of law, if any peace officer is convicted of or pleads guilty or nolo contender, in other words, doesn't wish to contend to the charges, to a crime involving the unlawful use or threatened use of physical force, a crime involving the failure to intervene in the use of unlawful force, or is found civilly liable for the use of unlawful physical force, or is found civilly liable for failure to intervene in the use of unlawful force. The POST board, which is the Police Officer Standards of Training, equivalent I believe to our Professional Standards Department, I assume, shall permanently revoke the peace officer's certification. The Post Board shall not, under any circumstances, reinstate the peace officer's certification or grant new certification to the peace officer unless the peace officer is exonerated by a court. The POST Board shall record each decertified peace officer in the database created pursuant to section 24-31-30. In a case in which the prosecution charges a peace officer with offences related to and based upon the use of excessive force, but does not file charges against any other peace officer or officers who were at the scene during the use of force, the District Attorney shall prepare a written report explaining the District Attorney's basis for the decision not to charge any other peace officer with any criminal conduct, and shall publicly disclose the report to the public, except that if disclosure of the report would substantially interfere with or jeopardise an ongoing criminal investigation. District Attorney may delay public disclosure for up to 45 days. The District Attorney shall post the written report on its website, or if it does not have a website, make it publicly available upon request. Nothing in this section is intended to prohibit or discourage criminal prosecution of an officer who failed to intervene for conduct in which the facts support a criminal charge, including under a complicity theory or for an inchoate offence, if that's how you pronounce it. Now, what I take from that is that if the use of excessive force is found, then unless the District Attorney specifically explains why the other officers at the scene shouldn't be charged, they should and will automatically be charged for not intervening, which is exactly what we have all been saying for some time that needs to happen here. Now, the second part of the bill is regarding body-worn cameras, in which it states, the state and the Colorado State Patrol shall provide body-worn cameras for each peace officer of the law enforcement agency who interacts with members of the public, except as provided in subsection 1A2B or 1A2C of this section. A peace officer shall wear and activate a body-worn camera or dash camera if the peace officer's vehicle is equipped with a dash camera when responding to a call for service or during any interaction with the public initiated by the peace officer, whether consensual or non-consensual, for the purposes of enforcing the law or investigating possible violations of the law. If a peace officer fails to activate a body-worn camera or dash camera as required by this section, or tampers with body-worn or dash camera footage or operation when required to activate the camera, there is a permissive inference in any investigation or legal proceeding, excluding criminal proceedings, against the peace officer that the missing footage would have reflected misconduct by the peace officer. If a peace officer fails to activate or reactivate his or her body-worn camera as required by this section, tampers with body-worn or dash camera footage or operation when required to activate the camera, any statements sought to be introduced in a prosecution through the peace officer related to the incident that were not recorded due to the peacekeeper's failure to activate or reactivate the body-worn camera as required by this section, or if the statement was not recorded by other means, creates a rebuttable presumption of inadmissibility. Notwithstanding any other provisions of law, this subsection 1A3 does not apply if the body-worn camera was not activated due to a malfunction of the body-worn camera and the peace officer was not aware of the malfunction or was unable to rectify it prior to the incident, provided that the law enforcement agency's documentation shows the peace officer checked the functionality of the body-worn camera at the beginning of his or her shift. In addition to any criminal liability and penalty under the law, if a court, administrative law judge, hearing officer, or a final decision in an internal investigation finds that a peace officer intentionally failed to activate a body-worn camera or dash camera or tampered with any body-worn camera or dash camera, except as permitted in this section, the peace officer's employers shall impose discipline up to and including termination to the extent permitted by applicable constitutional and statutory personnel laws and case law. In addition to any criminal liability and penalty under the law, if a court administrative law judge, hearing officer, or a final decision in an internal investigation finds that a peace officer intentionally fails to activate a body-worn camera or dash camera, or tampered with any body-worn or dash camera, except as permitted in this section, with the intent to conceal unlawful or inappropriate actions, or obstruct justice, the POST board shall suspend the peace officer's certification for a period of not less than 1 year, and the suspension may only be lifted within the period of suspension if the peace officer is exonerated by a court. In addition to any criminal liability and penalty under the law, if a court administrative law judge, hearing officer, or a final decision in an internal investigation finds that a peace officer intentionally failed to activate a body-worn camera or dash camera, or tampered with any body-worn or dash camera, except as permitted in this section, with the intent to conceal unlawful or inappropriate actions or obstruct justice in an incident resulting in a civilian death, the POST board shall permanently revoke the peace officer's certification, and the revocation may only be overturned if the peace officer is exonerated by a court. Now, there is a lot more to that bill, which I will link to in the description, but it is a very interesting read. And when you think that in lots of cases, what happens in the USA doesn't take too long before it happens over here, then this could be a great starting point for holding police to account properly here in the UK. Personally, I think, to hold them accountable, unless there is a genuine reason why they shouldn't be held accountable, rather than to not hold them account unless there's a genuine reason to hold them account, I think is the way forward. That will certainly stop, I think, police acting in the way that we see and hear of all too often, leaving us, the members of the public, picking up the pieces whilst some copper is off on suspension for a few months or a few years, getting paid while they investigate whether he shouldn't be charged with something, rather than investigating if he should. I think it's a great idea. What do you think? Let me know in the comments.